the Pearl Cohen Tzedek Latzer Baratz LLP webinar, a live stream through Facebook and other social technologies. Today we'll be discussing You Don't Know What You've Got Till It's Gone, Maintaining and Abandoning U.S. Non-Immigrant Status, Green Cards, and Citizenship. Today, your presenters will be myself, Ari Farkas. I'm the chair of the U.S. Business Immigration Group here at Pearl Cohen, based out of New York. And my associates, Dela, Leybovich, and Rebecca Lenetsky. Just a quick background on Pearl Cohen, in case you don't know already. We have 6 offices worldwide, 8 foreign desks, offices in Tel Aviv, Haifa, New York, LA, Boston, and London. We are the largest patent law firm in Israel, and we primarily represent innovation-driven enterprises, which really melds well with an immigration practice, because so much of what we do is representing people entering the U.S. markets or acquiring talent from abroad. And especially innovation-driven enterprises are focused on the best talent, the best of the best. And so there's a very, we provide a very substantial service to the clients of the firm. As I said before, I'm the partner and chair of the U.S. immigration firm. This is a quick overview of my associates who will be addressing you as well today on different topics. So in today's world, not just the current political climate in the United States, but also with regard to COVID-19 and other challenges that we're facing, we find that maintaining immigrant status or non-immigrant status in the United States is of key importance. There's a lot of uncertainty. There's a lot of the political realm, clearly, but also just within the economy. And so we find ourselves constantly being asked about maintenance of status. And we have told our clients over and again, we've apprised them of this is the most important aspect right now, is ensuring that all options are available and that you don't in any way step out of status in the United States. We wouldn't want to be in a situation where in 6 months from now, we realize that something has gone awry and therefore you failed to maintain status. You haven't, or the client or the beneficiary of that client that hasn't maintained their status. And therefore now we're in a situation where we're spending a lot more time attempting to clean up certain situations that may not have a resolution that's positive. Not so much because of our efforts, but also just because there may not be an available scenario. So maintaining status in the United States, I'll start with some general tips, and these are very important. The first thing is, upon entry to the United States, it's important to check online the I-9 record. It does happen. I wouldn't give a percentage, 10%, 15%, but it happens more often than we'd like, that the I-94 entry record there's an error in that record, whether it's defining the correct status or the correct expiration dates. And it's very important to check this, because if we find an error right away, then we can usually correct this either by calling CBP or if need be going down to deferred processing, usually an office at one of the larger airports. There's one in Newark, there's one in JFK, and they're throughout the country where we can attempt to correct this issue. So for example, a common error would be someone entering the United States on a blanket L. So the company has been granted an L and they're entering, and the CBP officer may look down and see that the blanket L is set to expire on a specific date, but the 3-year term, the amount of time the person can stay in the United States, is longer than that. And they're supposed to connect it to the date of the individual's visa. And sometimes they'll restrict it. So what they'll do is they'll see there's maybe 6 months or a year left on that blanket, and they'll limit the entry to that 1 year. But in truth, they should be extending it for the full 3-year term. And so, lo and behold, a year passes by, a year and a half, the person leaves the country, they come back in, and CBP says, wait, you overstayed your last visit. And so again, this is a simple thing to fix, but it's something that, as I said, this is good practice. Every time you enter the country, wait a day, go check online the I-94 entry record, and they no longer give you cards, with the exception of certain situations. And then you'll be able to see what it is. And if there's an error, again, contact your attorney. We can assist in fixing this, because this can balloon into a much larger problem, especially if it's not caught before the expiration date. Another thing to check is the visa stamp and visa status. So a visa stamp is a travel document, and we get this question often, where the dates on the document don't always match the dates of travel. For example, you may enter while you're still in valid status, and the visa stamp itself may be valid for a certain period of time, and you enter and you'll have 6 months from that date, even though the visa stamp may have expired. So it's important to recognize that the date on the visa stamp is what allows you to enter the country, but doesn't necessarily control the end date, depending on the type of visa stamp. Certain ones, employment-based, clearly do. Under a change, it was, I think, 4 years ago. Now you get your length of employment plus 10 days. But sometimes, again, the visa stamp may be limited due to, for example, if you have a master's degree in a science, and hard science, they will limit it to 1 year, or if there's a security concern, even though the underlying employment is 3 years. And so by keeping track of the visa stamp, the statuses, the dates, it's very important to make sure that all these things line up. So that way you don't get a rude awakening one day, either by trying to enter the United States or by overstaying your time in the United States. The risks of overstay, though, is after being in the US for 180 days, there's a 3-year bar to reentry. If you stay to 365 days, that extends to a 10-year bar. And what's important to notice about this is that, we get the question all the time, and I want to be very clear about this. Technically, you have that 10-day period at the end of your H-1B. You have time after a status ends if there's a termination, but the question will come up at the consular offices: how much do you overstay? And if it's more than 180 days, you do incur that bar. But if you stay 175 days, there may also be a negative consequence. So there's an underlying understanding of reasonableness. It took you a week to get your apartment sold or your apartment cleaned out, to collect all your possessions, to leave the country. That's understandable. But to extend to 170 days, and though you don't even hit the 3-year bar, there has to be a good reason, because that will come up at a consular interview in the future. Just as an aside, this does not apply to children under 18 years old, and that is an important thing, because it does happen from time to time where children may not. This occurred to us a couple of years ago, where a child entered with a family. It was an adoptee in a foreign country. It was a U.S. citizen parent and a green card holder. Other parent, the child did not become a citizen when they entered, because the adoption occurred and completed in the foreign country. They entered the country and they didn't realize that the child was entering on a different type of visa that the parents entered on, and so they overstayed. But again, there was no issue, because they were under 18 years old, and they were able to quickly correct this. Now, another thing to think about, again, there's a lot of information here because of what's going on, but another concern is that there's a material change in employment. So for example, if you're working as an H-1B or an L visa, and the employer makes a statement: everyone is now moved to part-time, compensation is now reduced by 25%. We have to look at this on a case-by-case basis to see, has there been a substantial change or significant change to the circumstances, which may then require an amended petition. So in some cases, and it also depends on how the initial application was filed. Sometimes we'll have an application that's filed as full-time, and now a change to 2/3 time or will be significant because the prior application was restrictive. It only said we have to have someone full-time. However, if the initial application was a range between 20 to 40 hours at this pay scale, then change, then we really are required to go ahead and file an amended petition and to get that fixed. Sadly, right after the Trump administration began, they changed a significant boon to applicants, in that it was given a certain benefit of the doubt if you have a previously approved application. However, now we're seeing that these things are reviewed anew, and so therefore no benefit of the doubt is given. And we have seen, and this shouldn't be a reason not to file just because of uncertainty, but we have seen cases where previously approved applications were rejected while filing for an amendment. But it is important to note that so long as the initial application or the underlying application is still valid, even the amendment, if it is denied, that still underlying application may still be in place. And so again, it's a matter of how to set this up in a way to protect the beneficiary and the employer when this happens. I just want to point to the 60-day grace period after termination. We're sadly involved in a lot of terminations. H-1B employees, when they're terminated, one of the requirements is to inform the US government. But the way it works is, and again, this goes back, I don't know, 6 years, I think, 5 years, there was a major change, and this was a fantastic change, I'll be honest. But it basically says that if I'm terminated, let's say I have an H-1B, and the H-1B is set to end on January 1 or December 31, 2020. So if the person is terminated or quits, it doesn't make a difference who initiates the end of the relationship. The beneficiary may remain in the United States for 60 more days without any issue. And if they find a new employer and that new employer applies for them, there's not considered to have been any type of hole in their validity, in their status while they're here. So they apply as a change of status. They don't have to leave the country, and as long as the application is made within that 60-day period. Now, this clearly shows you, as noted above, the 180 days unlawful presence. This 60 days, it's assumed now that H-1Bs or Ls or Os or any employment-based visa type will attempt to find a new position. And so therefore, that first 60 days is very much understood as why you haven't left the country for that 60-day period. However, you cannot travel during this 60-day period. You cannot say, okay, I've been terminated, or I've terminated my relationship on the first week of July, and now I'm going on vacation August 1st to August 15th. I'm going to leave the country and come back in and continue my search for a new job. It doesn't work that way. You need to remain in the United States during the 60-day period, and if you leave, the 60-day period ends. The flip side just on this, that 10-day period, as I mentioned, is it's the lesser or the later of the earlier of the two dates. So if you terminate your relationship on December 15th, and again, your visa was set to expire, your employment was set to expire on January 1. So you get to January 1 plus 10 days. You wouldn't get 60 days from the date of termination. It's the earlier of 10 days after the expiration of that intended visa or that intended status, or 60 days prior to that 10-day period, or prior to that date plus 10 days. So there is a grace period. I don't like the word grace period, but there is a grace period for this. There is a time to seek new employment, and there's a time to maintain your status during this period. And we found a lot of people utilizing this, especially now, where we've been dealing with COVID now 5 months or so, and some companies are now doing another round of layoffs. And so this is an important time to know about the 60-day grace period, how to use it properly, and how to maintain it so you can maintain your options. Now, with regard to extending or changing status, this goes to that 60-day period again. One of the ways to do it is if you file while you're still on your visa, called timely filing, then you can stay in the United States for 240 days while you're waiting for that extension of status to go through. So as long as we can show that it was timely filed, and timely filed means that 60-day period, and the 10 days after the expiration are all considered timely filed, and you can remain in the United States while the application is pending. If it's an extension, though, you can continue working for your employer. However, if it's a new employment, then you cannot, with the exception of an H-1B, in certain situations, you cannot just go to that new employer. You have to wait till the application is adjudicated. We do have premium processing. It was reinstated in June. And so for an additional fee, you can request the government to adjudicate within 15 calendar days for additional $1,400, $1,440. And so you can get to your job sooner by doing so. So again, you can apply for this extension. You may remain in the United States. In some cases, you continue working during that time. And when approved, you get that validity date, but it's backdated to the prior date. So for example, again, if your January 1st is the end of your status, and we filed on December 15th, and now it takes them 3 months to make a decision, well, you get that period, but going backwards to January 1 for 3 years. You don't just get it. You don't gained that 3 months where they were adjudicating it. Just as a question of timing, you can apply for your extension or your change, well, the extension, 6 months in advance of expiry. That is the earliest you can file for it. Any earlier, and they will reject the application. We suggest now, and this has become our practice, that literally we start working with clients to file extensions. We'll call them 6.5 months out, so that way we can file on the earliest possible date, so we don't have to incur the additional $1,400 for premium processing. It gives the U.S. government a sufficient amount of time. And should there be an issue, let's say we do get a denial, which, as I said, because of this change, we're no longer giving the benefit of the doubt. Should we get a denial, we then have the time to reapply, and there are many different ways to do it, or in some cases appeal, but it gives us that time frame to do so. Also, if there's a request for evidence, it gives us the ability to respond to that request for evidence, and hopefully have a decision from the U.S. government before that 6 months. Now, there are times where clients have said, no, we want to apply the latest possible date. We don't want to apply for premium processing because the project will be over in 5 months or 6 months anyways. And so they'll say, can we apply on, in our case again, December 31, have the application received at USCIS on December 31, and not pay for premium processing, and let it take 4 months for them to adjudicate. And if it's approved, then we've got the 4 months and 2 more months for the person to finish the project. Or, at the end of the 4-month period, if it's denied, that's fine. We'll make do for that remaining 2 months of that project. And I've had this with a number of financial institutions where they had very specific projects. And they've said, no, this is the way we want to move forward on this because of the timing. It just doesn't make sense to us to apply early, which may then curtail our ability to use the employee during that additional time period. Okay. If the status has not been maintained, okay, and this is important, the extension may be denied, but the underlying petition may be approved. And this is what I think I explain this to all my clients up front, is that every application that's made of the U.S. government has 2 pieces to it. The first piece is the petition. The petition's made by the employer or the relative or whomever it makes that petition. That petition is made to the U.S. government. Then, once that petition is approved, then the question is, now what happens to that approval? So if the person's abroad, it gets transferred to the Department of State, and then we schedule an appointment for the person at a consulate. But if they're in the United States, we can ask for their status to be changed or extended. If they did not maintain their status, then the underlying petition may be approved, but they'll say, we can't change your status. That application to change status will be denied. The underlying petition will be approved, and then the person will have to seek a visa outside the country. If we made an application for changing status and it was denied in the United States, then that person must return to their home country to seek a new visa. They can't go to a third country to request that. And that's sometimes we take into that account is we say, will this be harder for the beneficiary to have to travel, let's say, back to Australia for a certain type of visa, while we can send them to Barbados if we ask permission beforehand. So instead of requesting to change status, we may strategically decide to request consular processing and send them out of the country, but to a closer consulate that will accept them and then have them come back to the US to start work, rather than taking the chance and then being restricted to only using that consulate. Just as an aside, even if there is a scenario where the person did not maintain status, this actually just occurred to us, where a client had been using an attorney who, it turns out, ended up in the hospital and had substantial medical issues, and so therefore didn't respond to the client, and in the end missed the filing deadline. We were able to file and request what's called dunk pro tunk, which is we essentially state, we ask for forgiveness based upon these, third party issues that occur that are really no fault of our client. And the U.S. government, if you have a good reason, they will grant you this kind of retroactive approval back to when you were in status. And so again, but that's a case-by-case basis, but it is something we've gotten for our clients when there was a reason and it was no fault of our client. That's the 2 real things. You need to have a good reason, and it has to be no fault of yours to maintain your status. So just as another change that occurred this past year was that it used to be when I filed my application for an extension, right? I'm here on an H-1B, I'm hitting year 3, I file an extension now, my wife and kids are here with me. So we would file everything together, and if we premium process it or even not, then the spouse and children's applications to extend status would be all adjudicated at the same time. So we'd get the approval notice for the beneficiary, and then their dependents would come at the same time. They created a requirement now to have fingerprinting done for all people requesting extensions of status. And what that did, it uncoupled the application. So now the application that we make on behalf of the beneficiary, the employee, will get approved at one time, and the extension and change of statuses of the dependents are now on a separate time frame. Now they can remain in the United States. If they're in school, they can continue being in school. If they are an L2, they need to apply for a new employment authorization document, which can only happen at the time that they have an approval. But again, that's part of the strategic planning, is to recognize that we may have that you can remain in the United States, but it's on a separate time frame. We move at a slower pace, at a different pace, because it's now coupled with all extensions, all change of status, and the beneficiary may have an approved visa. At that point, we may say, again, travel. Now, clearly right now it's impossible. The consulates are closed. With COVID-19, travel becomes harder, especially to Europe, to Brazil, to China. But hopefully things will get back to normal with the consulates. We're seeing some consulates opening. We might suggest to abandon our request to change status for dependents, and everyone go out of the country, go to Barbados, go to their home country, and then seek a new visa, come back in, and they'll be in that new status sooner than they may if we just waited for them to change status in the U.S. So, as I mentioned before, we are seeing under the COVID-19 has created substantial issues, and also a lot of policy changes that we're relying upon, a lot of unique challenges. For example, from our employers, we're seeing furloughs or pay cuts that affect different visa types differently. And this is important. The H-1B visa, for example, if you have a pay cut and that pay cut then goes below the prevailing wage that was applied for on the labor conditions application that accompanied your H-1B petition that was through the Department of Labor, then the company there can be serious consequences for the company, because they have made a commitment to pay that minimum salary. If they take an H-1B and they say, listen, just stay home, we're benching you, that can create serious repercussions. And so we've counseled our clients. They have to be aware that when they treat H-1Bs, that they have additional responsibilities, not just to USCIS, not just to the employee, but also the Department of Labor. And they have to maintain those responsibilities. Otherwise, there could be, in addition to just normal liabilities, I mean, we're talking about multiples of fines and payments, and they're made both to the Department of Labor and to the employee. So if we are making a change, if we are putting someone aside, if we are going to lower salaries, it's very important to have a conversation, because I pointed out before, we also want to make sure that that if a change is considered to be substantial, then we may even need to go so far as to file a new application. And this goes to changes of location as well. So there was a memorandum that came out maybe a year ago or 2 years ago as to the definition of what is a change location. A change in location of employment that does require an amendment. It wasn't clear. There are still gray areas in that. People take the view that as long as you're within commuting distance, and this is extremely important at the time of COVID-19, where you may have an office in Manhattan and now your employees are all working from home. Well, if that's in a different metropolitan area, let's say I'm now working out of Nassau County because I took the train to Manhattan every day, that might be sufficient. And so we can rely upon the normal commuting distance generally, but again, that's something you want to talk to an attorney about, because we've had clients with employees who traveled 2 hours every day to get to their offices. And so this is an important, I'd say one of the most important things, to reach out to an attorney to discuss it with them, because this can have a substantial effect in the H-1B category, but also in other ones as well, because again, it may go to a substantial change in the employment. H-1B is clearly because we define the area, the location of employment. But I would say even in an O or an L category, I would have that conversation, even though there's less of a concern. I'm sure everyone knows about the presidential proclamations from April and July, the first one affecting immigrant visas to the US, and the second one, June actually 22nd, affecting workers in H category, in the L, intercompany transfer category, and certain types of Js, those au pairs, trainees, teachers, which was very concerning, as well as one for J's, trainees, interns, teachers, and au pairs. And essentially what they did was say that we're pushing off till December 31st at the earliest, any visa issuance. So if you had your visa prior to that date, you can come to the United States. However, if you don't have your visa, if you don't have your immigrant visa, that was the April one, we're not going to issue you a visa and you're able to come to the United States. And that April one has sparked a few lawsuits, specifically with regard to the diversity visa lottery, people who won the lottery, who are waiting for their interviews, and who now, because they need to have that visa in their passport by September 31, or they've lost their number, have no chance of getting it. And there are at least, I think, 3 lawsuits pending in Washington, D.C. to seek to either have the date extended to after the December 31st deadline or validity period for these proclamations, or to carve them out of the proclamations and start processing. But clearly the biggest issue that we're dealing with is the consulates are closed, with the exception of cases that are considered national interest. So if you're a doctor, just recently I was consulted about a doctor who was coming to the US in order to provide medical services for cancer victims, specifically who have COVID-19. And the US consulate did issue the visa, but it took some time for them to get permission from the Department of State of the United States before they would issue that visa. So there are times where the consulates are still working. However, the consulate's Department of State has made it very clear that the highest priority for them is to maintain the health and well-being of their employees, and they will not put them at unnecessary risk. And so there are no interviews for H's, L's, J's, for immigrant visas generally. So these presidential proclamations have a very strange effect in the sense that they are limiting the ability to get these visas. At the same time, there is no real way to get the visa unless there is a national interest applied to it. And again, this is going through December 31, but we are seeing even today, I haven't had a chance to review it, I understand the Department of State expanded the list of national interests that were the national interest waivers, essentially, that would allow people to come to the US or to seek visas at those consulates or travel. And then last point is ICE announced, Immigration Customs Enforcement announced that student visa holders would not be allowed to attend online only programs. And this is one of the things we're watching in the news. How is Harvard, how is MIT, how is, even our local Rockland Community College, Bergen Community College, how are they dealing with classes for next year? And a lot of schools have decided to go online only. So Immigration Customs Enforcement made a statement that they would not honor. They would say that if you're in the US and your school is online only, that's not a valid visa, and you'd have to leave the country and go home. However, there was a lawsuit filed by Harvard, MIT, amongst others, and this was retracted on July 14th. Additionally, we've seen that J students and F visa holders applications from outside the country are being given priority at the consulates so that they can enter the United States and they can attend school. While the consulates are still closed, they'll try to get them in for interviews, despite the fact they aren't really having public interviews right now. So before I hand this off to Rebecca Lenetsky to discuss maintaining immigrant status outside the United States, I just want to make a final point about non-immigrant status. So if someone's in the United States on, let's say, an H-1B visa, so the H-1B visa is initially 3 years with additional 3 years, a total of 6-year period. But if you're stuck out of the United States, there's no concern about maintaining status. If you've left the country for 8 months and you come back in, you're still an H-1B. We don't say that H-1B has been negated, it hasn't been abandoned. The H-1B still exists, you come in, you continue working. In fact, at the end of your H-1B, when your 3 years are over and then your second 3 years are over, we can go back and say, well, the person was out of the country for 8 months. We're going to request to reclaim that time. Same thing for the L, which is an L1A is 7 years, 3 years plus 2 years plus 2 years, or the L1B, which is 3 years plus 2 years. So we can request to reclaim that time. So we're not penalized for being out of the country, but there is no requirement to maintain your non-immigrant status if you're outside the country. In some non-immigrant statuses, such as the O visa, where there is no technical limit, it's a 3-year visa, but you can apply for another year or another 3 years, depending on the specific circumstances, over and over again for years to come. So in those cases, being outside the country just runs time on this specific visa. We can't request to reclaim because there is no total limitation. However, in an H-1B scenario, if you've been out of the country for 11 months, we might want to say, wait another month and we can resubmit you into the lottery and try to get you an additional 6 years, because being out of the country for a year might gain you that capacity to get an additional 6 years. But again, that's a conversation to be had. One last note, which I failed to mention earlier, a lot of these restrictions upon entry, those two proclamations don't apply, or at least the latter one doesn't apply to Canadians, because they don't need visas issued to them. They can just enter with an approval notice and their passport. There are other restrictions due to COVID-19 agreed to with land borders, but it shows that those presidential proclamations are really restricting something that already is restricted and not much more. All right, so now I'll turn it over to Rebecca to discuss maintaining immigration status outside the United States.
Okay, hi everyone. So a question that we would get a lot before the COVID era was about maintaining your green card if you, for whatever reason, wanted to remain out of the United States for long periods of time. You may have gotten a green card at a time when you were in a period of transition, you were still in school, you had to wrap things up in your home country, maybe you just wanted to stay a little bit longer, keep working there. So there are a lot of reasons why people with green cards would still want to be remaining outside the US. A question we get more frequently now that COVID has become an issue is, what if I literally cannot leave my country and come to the US on my green card for X period of time? Now, none of the travel bans into the US from Schengen, from China, from Iran, from anywhere apply to green card holders. So you can take your green card and come into the US. If you have a valid green card, you can get in. However, there's some travel restrictions within the countries themselves, and you cannot physically get out of your country, you can't find a flight, you have health concerns, and you're an at-risk population. So now that COVID has become an issue, we are getting questions also about, what if I literally cannot get back? So if you had this plan from before, and you knew when you were leaving the US that you would potentially not be back for long periods of time. And long periods of time means over 6 months or over a year. If you were going to be absent from the US and you knew it was going to be for more than a year, then we would always recommend that you must prepare for this by filing a re-entry permit, because as soon as you are out of the country for more than 1 year, your green card is technically invalid. The immigration services, various agencies assume that you have abandoned your permanent residence in the United States. Even if you've maintained your residency here, the assumption is that you've abandoned it. Even if you have an apartment here, if you have a bank account, you have to then prove that you have not abandoned it, which becomes a much more burdensome issue. If you've been absent for more than 6 months, but for less than a year, when you attempt to re-enter on your valid green card, CBP or another immigration agency may determine that you have abandoned your residency even if you've only been out for 6 months. And then you may also have to show proof that you have maintained your residency here, you have maintained your apartment, you've maintained your ties here, you've maintained a bank account here, but it still may become an issue in order to establish this to the immigration officials that you encounter, whether at CBP, whether in other contexts. So in either of these two situations, if you know you're going to be out, or if there's a high probability that you're going to be out of the country for more than a year, or if there's a probability that you'll be out for more than 6 months, then we recommend that you file what's called a re-entry permit. The reentry permit acts as proof of your intention to maintain your lawful permanent resident status, even if you're going to be out of the country for over a year. So if you have this document in hand, there's very little that a Customs and Border Protection officer can say to rebut the presumption that you have maintained your residency. You have declared in advance your intention to return. The reentry permit is a document that's normally valid for 2 years, but you must file it while you are physically in the United States. So you have to be in the country, and the paperwork needs to be received while you are in the United States. So that means you can come into the country for 2 days, file the reentry permit, and leave, with the caveat that you also have to have your biometrics, so your fingerprints and photo taken in association with the application. So that usually means another week or two, potentially longer, depending on the general circumstances in the country. There are ways to expedite this. We can sometimes get you an emergency biometrics appointment, but generally speaking, you do need to be here for the filing. You could come back and get your fingerprints taken at a later date, but it needs to be within this generally short period of time. So, and then after that, after you've had your fingerprints taken, you can leave the country and you can remain outside the country until the reentry permit is approved, get the reentry permit mailed to you. Usually when we're representing a client, we have it come to our office and we send it to our client abroad. And then you can use that little reentry permit that looks like a passport to come into a sort of mini US passport that isn't a US passport, to come into the United States anytime within that validity period. The reentry permit can be extended in theory indefinitely. So you can keep getting it in 2-year periods. However, if you got your green card, the next day you filed a reentry permit, you left the country, you're out for 2 years. You come back before it expires, you file the reentry permit, you leave again 2 weeks later, you stay out for another 2 years. You come back and you say, okay, I'm ready to file another reentry permit. At that point, you've been out for 4 years out of the 5 years since your acquisition of lawful permanent resident status, since you got the green card. At that point, most likely, USCIS is going to start issuing the reentry permits in 1-year increments, with the assumption being that we don't really see that you have the intention to be here as a lawful permanent resident. We're going to give you shorter opportunities to stay out, sort of giving you a nudge to make up your mind. In theory, we never see these denied, but it clearly is the intention of USCIS to encourage you to take up your residency in the United States. We are seeing some situations, especially now COVID, where people are stuck outside the country with their reentry permits coming up for expiration. I'm going to let Dela talk about what happens if you're in that circumstance, because she'll talk about getting specific travel documents if you are out of the country without, for over a year without a reentry permit to come in. So we are seeing those situations, and I'll let her talk about what your options are in that case. Moment. When you file a reentry permit and stay out for more than 6 months, or clearly more than a year, you have broken your residency for naturalization purposes. So if you want to go file your citizenship, even if you were here for 4 years straight, so you have the number of days that you need to be in the country for citizenship, then you leave on your reentry permit and you're out of the country for over a year. You still have the correct number of physical presence days that you need in order to file for your citizenship, but you've now broken the continuous residency in that prior 5 years. In certain circumstances, when you are leaving for a long absence, which is for certain employment purposes, you can file an N-470, which is an application to preserve your residency for naturalization. Just basically saying that you know you're going to be out for a long period of time, so over 6 months, and certainly if you're going to be out for over a year, but it's for a specific purpose, and these purposes are very specifically defined. It's usually It's a variety of situations where you're working either for the US government, or if you're working for a US corporation or institution, often research institutions, that in some ways are furthering the interests of the United States, whether it be, again, research, trade, property interests of the United States. So it's reasonably constricted. It can't, you know, they don't read this so expansively. You can always make an argument for this, and try your luck. And otherwise, if you do break your residency, so you stayed out for 6 months and you cannot give a good reason for why you had to stay out, it was within your power to come back, you broke your residency, your continuous residency, then you have to wait again for another 5 years continuous residency, or if you're married to a US citizen, 3 years continuous residency. You haven't lost your green card. If you stayed out for less than a year, whether or not you have a re-entry permit, you can come in, you have your green card, but you lose certain benefits that go along with that would lead to naturalization. And now I will turn it over to Dela. If Ari, you want to say a word.
Thank you, Rebecca. Yes, we'll talk about SB1 returning resident visa. As Rebecca mentioned earlier, a lawful permanent resident or conditional resident who has remained outside of the United States for longer than 1 year or beyond the validity of a re-entry permit will technically be considered to have abandoned his or her LPR status. To re-enter the United States to resume permanent residence, this individual will require a returning resident SB1 visa. Please note, if you're the spouse or a child of a member of the US Armed Forces or civilian employee of the US government stationed abroad, you would not need the SB1 visa. So what are the qualifications and process for the returning resident status? Under provision of immigration law, to qualify for the SB1 visa, you will need to prove that you had a status of lawful permanent resident at the time of departure, departed the United States with the intention of returning and have not abandoned this intention, and are returning to the United States from temporary visit abroad, and your protracted stay was caused by reasons beyond your control. To secure a returning resident SB1 visa, you will need to be approved, 1, for a returning resident status and usually later for an immigrant visa. To make the SB1 visa request, you should complete the application to determine returning resident status and provide documents that demonstrate, 1, your ties to the United States and your intention to return, and 2, that your protracted stay outside of the United States was for reasons beyond your control. A consular officer then will review your application and supporting documents and determine whether you qualify for the SB1 visa. If your visa request is approved, you will be eligible to attend an immigrant visa interview. To apply for an immigrant visa, you will be required to complete an immigrant visa and affidavit of support applications, pay all appropriate fees, obtain a medical exam report, and attend an immigrant visa interview. If your application for SB1 visa is denied, you can still apply for an immigrant visa on the same basis and on the same category. Now, a question of the day, which we receive a lot these days, is whether to wait for the consulates and embassies to reopen and apply for the SB1 visa, or travel to the United States and present to Customs and Border Protection. Today, there has not been any announcement or policy exception issued by USCIS regarding this issue. So our position is that the SB1 is still the safest bet. If someone chooses to fly to the United States and is granted entry, the individual might still be negatively impacted down the road. That is all for now.
Thank you, Dela. So now we're going to turn to if someone wanted to actually abandon their green card status or their U.S. citizenship, and the question comes up why someone may want to. You may have political reasons to do so, or prevailing reason that we've heard is taxation. If someone's living abroad, their time in the U.S. has come to an end. You're still required to file taxes in the United States, and you may choose to say, "Listen, I don't want to," even if you don't owe taxes per se. I don't want to have to deal with that. They may choose to give it up. So today we're just going to focus on we just discussed maintaining, but it's also a good time to think about, well, whether or not should we decide not to maintain it? How do we make sure that we take whatever proper steps are required to ensure that we have properly, properly given up the status or surrendered that status? So abandoning U.S. permanent residency prior to June 1st, 2019, this was done at the consulates. You made an appointment, you brought a form, and you were able to give up your card and receive a receipt notice stating that you've given up your status. This can also be done at a border protection, customs border protection when you're entering the United States. You can say, I want to give them my card and enter under a different status if you have a valid visa. If you're a European citizen, or I'm sorry, if you're a citizen of any country that has a visa waiver program, attempt to enter that way. But as of June 1st, things have changed. The preferred way to give it up, or the way that you're supposed to, is mail your card to an address for USCIS in the United States. They then issue a receipt that they've received it. They're supposed to issue a receipt, and then they'll issue it should be issuing a document saying they've given up your status. Now, from the tax perspective, the date for abandoning is very important. Again, we have a tax partner who I can introduce you to, Dr. Osalabi, discusses more in depth, but my understanding is that IRS views green card holders in one of two ways. In the first 7 years, and when we take 7 years, I mean the 7 years, that means if you received your green card on December 31, that is year one for you. Even though it's only been 1 day, that is year one for you. So now the first 7 years, you're considered to be a lawful permanent resident. You're required to file taxes, and by giving up your green card within the first 7 years, with surrendering it or abandoning it, that ends your requirement to file taxes, and that's essentially the end of it. You need to have filed or returned that card to the U.S. government before December 31st of the end of the 7th year, before the 8th year begins, because in the 8th year, they consider to be what's referred to as a long-term resident, LTR. And an LTR has the same expatriation tax as if someone gives up their citizenship. And so therefore, that could create problems. You have to make sure that you pay your taxes. If your net worth is above a certain number, it could trigger a tax. And again, you should want to speak to a tax attorney or accountant to discuss more specifics, but it's important to keep track of those dates because there is that tax liability. But again, this is the way we have to give it up now. So the three ways to do it. The first one, which is the way that USCIS says to do it, is to send it to this address in the United States. The second one is if you are at CBP, Customs Border Protection, and this is something that they do, a little underhanded, but if you've been out of the country for more than 6 months, you enter, you're standing, you've been on a long flight, they'll say, we don't believe that you really have an intent to reside. We're not gonna let you into the country unless you sign this form, giving up your green card status, and then we'll let you in on it's essentially they're saying without a visa, it doesn't really make a difference. They'll give you a B, essentially for the purpose you're coming in as a tourist for 6 months, but you've given up your green card. It's a bit underhanded. And if you are considering coming to the US, you've been out of the country for more than 6 months, or even less than 6 months, but for a substantial period of time, let's say 4 or 5 months, it's important to speak to an attorney because they can give you the proper direction as to what documents you would need to show to prove an intent to reside, and should this happen, what to do about it. Just a couple of, the last thing is, it is still feasible to apply at a consulate to give up to abandon at a consulate, but the Department of State has set out very strict guidelines for it, and it's only in very, very, very limited circumstances because they'll argue just put it in the mail, and the date of taxation, by the way, is not sufficient for this. If you say, well, it's December 28th and I need to get this in before the 31st in order not to pay taxes next year, they'll say that's fine. That doesn't matter. That's not a sufficient reason. But again, and speak to an attorney, there are a very limited number of times where the consulate will still accept abandoning the card at their offices. Just a few notes on this. Abandoning the permanent residence is irrevocable. Once it's done, it is done. You can't wake up the next day and say, oh my gosh, I made an error. It doesn't stop you from applying again if you have a basis. For example, we have spouses of US citizens who will give it up, return to their home country, move back there, and then say, you know what, 5 years later, we want to go back to the US, a business, a job, or school has come up, we want to return, that's fine. You can apply again. There's no restriction on applying again in the future. And even, within a few months, if you plan on traveling to the US, then you will need a valid visa. What we used to do when we give up when we abandon the lawful permanent resident card and the status, we would concurrently file for a B visa at the consulate. So now you'll have to do it in 2 steps, which is give back the card. You'll need proof that you sent it in, because they'll say, well, you're a lawful permanent resident when you're coming for the B visa. So there is a little bit of you have to kind of work out that strategically to make sure that you can show that you've abandoned the application and you're applying for a B visa. You should travel with the documentation that shows you've been. So if you try to enter, CBP says, wait, you're a green card holder, why are you entering as a B? Then you can say, no, I've given it up. Here's proof of that. And so those are some of it. We have seen, and this has happened only once or twice, where people who were from countries that were part of the visa waiver program were called by their airline a few days before they're set to travel and told that they don't have a valid visa to come to the United States. We've been able to get them B visas in short order because we can show that they don't have intent to reside. They've given up their green cards. But that's one thing that if your future travel, you have future travel to the US, we would suggest getting a visa, even if you have the visa waiver, because we don't want any surprises later on. Now, with regard to abandoning US citizenship, things are a little bit more complicated.
Sorry,
Okay. So in order to formally renounce US citizenship, now, again, there's a tax issue here that may come up, but it's important to recognize that this process has to occur at a consulate. It has to occur at a diplomatic office outside the United States. It cannot be done from within the United States. You go in there, there's a form you fill out. You have to give a reason why, and again, taxation. But taxation is not a good reason, especially because there actually is a law in the books that says that if you leave the United States and you state that taxation is the reason, then you may be banned for life from re-entering the United States. This was I recall this most discussed on the news channels when one of the founders of Facebook decided to give up his US citizenship and move to Singapore. But we don't have any regulations on that as of yet. But again, they take you aside. They ask you if this is something you really want to do. They ask you why you want to do it. They'll then take it from you. They'll take your passport. They'll take the signed form. They have to witness it. It gets sent to the United States. Your name gets put on a register. It takes a few months before it officially occurs, but you will get a document that says you've given up your citizenship. You can apply for a green card. You can apply for citizenship in the future. But this revocation, again, is irrevocable unless, well, that's one of the reasons why they actually, they sit you down. They ask you, sure, this is what you want to do. They want to make sure that there's no question that this was your intent. But once it's done, it is irrevocable. You are no longer a citizen of the United States. You must have another country. They'll ask you that. They'll say, do you have another country for which you are a citizen? Because they will not allow you to just become stateless. And it's important to that intent issue. Children under the age of 16 and individuals with developmental or intellectual disabilities are presumed not to have the requisite intent. And so therefore it is very hard for them to give up citizenship. I wouldn't say it's impossible, but I would say that it clearly is against you to show the intent was there. But again, giving up citizenship has a lot of far-reaching consequences. We would suggest speaking to a tax attorney, and we can clearly assist you in the process. We've done it numerous times, but you have to be aware of it because it is a rather substantial step to take. And as a friend of mine who gave up his citizenship posted on social media that he gave up his citizenship and within a few weeks applied for a B visa and didn't realize how complicated that whole process was to come visit his family back in the United States. So again, this is something to be contemplated, discussed, recognize the consequence of, but if it's something that someone wants to do, it is feasible to do so. And there are, some would argue, benefits to maintaining only one citizenship and not maintaining, a cadre of US citizenship, Canadian citizenship, Israel, South Africa, but rather just kind of having one. I think that with that, we've
So I probably should have mentioned at the beginning that we can take questions through the Q&A in Zoom. I don't know if there are questions from the participants that just haven't been posted. We can certainly give people a couple minutes to post something now in the Q&A tab. Happy to wait for that.
Yeah. Otherwise, feel free to reach out to us. Here's our email addresses. You don't have to recall what we discussed to email us. We can all three answer questions on any of the topics discussed today. But again, we see that maintaining status or choosing not to maintain status and then deciding that this is the that they want to end the relationship with the United States. Those are fine, but there needs to be taking the correct steps to make sure that whichever path you go in, you do it fully with full knowledge in order to make sure to maintain all your options. Thank you for attending this live panel, live on Facebook. I understand this will be posted up on our website and YouTube for people to view later. And if you have a question, you think of it later, feel free to reach out to us by email. And just as an aside, just while we were on the call today, new releases have come up. As I said, the Department of State issued this morning expanded national interest basis for visas to the United States right now. And so this is a dynamic area. Things are changing. Things are constantly being added. Who knows what presidential proclamations may be coming down the road. So it is important that even if today you have, everything is buttoned up, maybe in the future, something may change. And so it's important to reach out to an attorney and speak to them to get I don't see any questions being asked, but I think we've been doing this for an hour now. So again, if you have any questions, please feel free to reach out to us. Thank you again for attending, and we'll be having more of these webinars in the near future.
Thank you, everyone.
Thank you.